And actually, I had a question that sort of, it relates almost to the front end, Mark, of what you're talking about here, and I'd like your thoughts, Griselle, and everybody else. A lot of the complaints about the immigration, sort of the earlier complaints about the immigration court system, is there's not enough judges, there's, the workload is very heavy, what have you. But it seems to me that that assumes a certain level of workload at the front end. In other words, there's a tool in statute that the executive branch has called expedited removal, which prevents people from being fed into the immigration court system in the first place. Because if everybody gets a bite at the apple, we could all be immigration judges, and there wouldn't be enough immigration judges to deal with it. So my question is, and it's a little bit outside the scope of the paper, but it is in a sense kind of antecedent to the paper, is part of the solution actually narrowing the doorway for people to challenge their removal in the first place so that you don't have as large a flow of people? I want Mark's thoughts first and then anyone else's.
First of all, Mark brings up what's called expedited removal. Expedited removal or expedited asylum, it's called both names, makes up 65% of all asylum cases. A person comes into the United States, usually through an airport, sometimes off of a cruise ship, and they claim that they will be persecuted if returned to their home country. They are immediately placed into what's called expedited asylum. An asylum official from DHS examines them, determines whether they have a credible claim, and if they do, they have the right then to pursue either processing through the immigration courts through a defensive application because they know DHS will try to remove them, or through an affirmative application because they're saying, DHS, regardless of what you say, I'm going to apply for asylum. Now, all that says is they get in front of an immigration judge. That's a very swift process, but it's turned out not to be a swift process. In 1996, Congress found in its House report that aliens were showing up at airports and off ships claiming persecution. They were then given the right to pursue an asylum claim. The fact is that more than half disappeared before court once they were admitted into the United States. Then we adopted expedited asylum, and that was to swiftly adjudicate their applications within 180 days. That's not happening. Most cases take about 5 years to adjudicate. Not all, but some take as much as 5 years to adjudicate.
For the federal government, 5 years, that's pretty fast.
That's pretty fast. But the point I want to make here is that since 2005, the last time Congress received any report from EOIR saying how quickly expedited cases are being heard and adjudicated was in 2004. Since 2005, Congress has heard nothing. So the very disorder they were attempting to address has been sunset by EOIR. They just decided on their own. We're not going to tell Congress how quickly we're adjudicating these cases. And so the very purpose of the expedited asylum statute has been defeated by the very people that are administering the act. We are not being told, as I've said before, the full story. And if we were, we as citizens, regardless of which side of the immigration debate we are on, and there just isn't one side, there are many sides, but regardless of which side we take, we have to conclude we're not getting the whole story, and if we were, we'd be better advocates for the positions we take. But for EOIR not to report on that critical statistic, expedited asylum is to betray the very thing that Congress authorized them to do in the first place.
Has Congress asked?
Has Congress asked? Ms. Ibarra, I don't know. But they have these hearings, they have the reports, and the reports go 129 pages each year, lickety-split. I promise you, they're no more than 129 pages long. And in 2004, they found room to report that, but since 2005, for some reason, they haven't.
So Congress hasn't asked?
Well, and they haven't reported it, so how can Congress ask?
Well, but if I want to know something, I ask you.
Indeed.
Right? So if I
That's a
don't
good
care,
point.
then I don't ask you. So the fact that you don't report it, it's not because it's because I didn't ask you. I
don't think there's any question that Congress can ask. As I said before, I think that
better, more transparent statistic making would make it easier for Congress to ask, but that doesn't mean that they can't ask in the absence of it. The one thing I disagree with what Judge Metcalf said in the last go-round is that I don't know that robust, transparent, honest statistic reporting would favor both sides or all sides of the immigration debate. If it would, we'd have it. So I think it's pretty obvious that people are playing fast and loose with the numbers for a reason, and if they didn't think it served their political position, they wouldn't do it.